Dick Heller forces another change to DC's gun laws, and an interview with legal expert John Monroe about the Kyle Rittenhouse not guilty verdict. That and more on this episode of the Weekly Reload Podcast.
I made the devil run. I gave him poison just for fun. I had one friend.
Welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I am your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and buy an exclusive membership today if you want to support independent and informed firearms journalism, which is what we bring to you and the rest of the world. The only way that will keep going is if people buy memberships. But on top of helping support us, you will also get exclusive access to dozens of news reports and analysis pieces published by myself and Jake Fogelman, my contributing writer here, who's with me today. So you'll also get to experience this podcast a day early and potentially be on the podcast in one of our member segments. So there's a lot to enjoy. And if you buy the annual membership, you'll get 2 months included in there for free. You get the cost of a year for what would be 10 months technically. So it's a great value. Go ahead and check it out. But first, we're going to start with Jake. Tell us just a little bit about some of the polling that we've written up recently and some of what you've covered on that front.
Sure, yeah. So a few big polls came out in the last week or so. Support for gun control amongst the general public is at a serious decrease. Gallup found that public support for gun control is at a 7-year low. I think 52%, they say, support stricter gun laws now, which is, pretty significant because just 3 years ago, after Parkland, it was upwards of 67% of people were saying that they're in support of gun control. And they found that the largest driver of that decline was actually among independents this time. Typically, it's Republicans that will drive low numbers for gun control support. But 15%,
there's a big partisan gap, right, of course. But the way that the independents move sort of can often tell you how the broader public is moving on an issue.
Right. Yeah. And their support cratered 15 points in this poll just from last year. So it's pretty significant. And then earlier than that, there was a morning consult poll. It was just a general issue poll, polling registered voters on different political issues going on right now. And they found that more registered voters support Republicans than Democrats on the issue of gun policy, which, as we know, is a proxy basically for support of gun control. Just the way that parties, excuse me, are ideologically sorted on the issue. And then another poll we didn't get a chance to write up yet, but there will be a piece forthcoming. Quinnipiac came out with another poll that showed the same trend that, support for gun control is way down. I think theirs found actually that more people support less gun control than do support gun control, which is pretty significant.
It's interesting to see the numbers actually flip in that Quinnipiac poll. Right. And I wonder if Gallup might see the same thing next year when they do their poll again, given the trend that's gone on. Obviously, there's some political considerations that happen with really all issues at this point, given how polarized the country is. But with Democrats in complete control of Congress and the presidency at this point, perhaps that's driving some of this. But I don't know if that's driving all of it, right? I mean, you actually did an analysis piece on this for the members that looked at what some of the factors are in why these numbers are moving the way that they are. So can you give us a little bit of insight there too?
Sure. Yeah. So as you said, obviously partisanship plays a big role in this. You tend to see numbers kind of flip flop depending on which party's in power. So there could be a little bit of a thermostatic response just to the fact that Democrats are in control. That being said, I think there's clearly a number of other things going on. We're coming off, record-setting sales to first-time gun owners. And we know from previous polling that people that own guns are vastly more likely to be opposed to gun control than people that don't own guns. And so if you're seeing millions of new people become gun owners, that's obviously going to drive maybe a little bit of a shift in people's attitudes toward future laws. And then obviously the big one is crime. We're seeing record increases in crime across violent crime, particularly. across the country right now. And in that same Gallup poll, they found that a record number of people are saying that they're buying guns to defend themselves from crime. It's up to 88% now, which is the highest they've ever recorded on that poll. So it's clear that people want access to guns. They're concerned about crime, and they don't want to see anything that's going to hinder their ability to protect themselves is sort of the takeaway I have.
Yeah, I think that's a fair view of things too. And you get it a little bit more into the details of that as well in the piece where you talk about, the experiences of some of these first time gun owners and how crime has played into their desire to buy guns and where maybe that is going here in the future. But people should, again, buy a membership and you'll be able to read the full piece. But
that's right.
I think it's very interesting. And these polls, I mean, the movement in these polls is pretty remarkable because it's not just one poll. It's not an outlier that you see this sort of effect happening in. And you've seen it also in President Biden's approval ratings, not just generally, which have also, obviously they've trended downward significantly over the past, month or two here. But I mean, his approval on guns, the gun issue, has been sliding almost since the very beginning of his presidency. Right. So you've seen this movement come across in all sorts of different polls on all sorts of different questions on the gun issue. And I think it's had a big impact as well on the ability of the president to actually pass the legislation that he's pursuing in regards to gun control. And so now he has to focus much more on executive actions where he is owning the full consequence of whatever political effect there is from doing these different actions, like his attempt to effectively outlaw millions of guns that have pistol braces attached to them, or expand dramatically the ATF's ability to regulate what constitutes a firearm. How that plays out once it goes into effect is going to fall completely on him politically because it was a unilateral move. He's the only one responsible for it. So it'll be interesting to watch that aspect of it. Of course, we also have another big story. We had a lot of news this week, actually. There was quite a bit. You also had Heller of the Supreme Court fame. He was the plaintiff in the famous Heller case, which established there is in fact a individual right to keep and bear arms protected inside of the Second Amendment. That was the result of his case. He's back now. He's sued DC a number of times since that first case, but his latest case, he has again won, although this time he won without actually getting a court order, which is fascinating development, actually. So DC, actually, can you give us a little bit of background? What did DC do in this case?
Sure, yeah. So last year, I believe, they passed a city law. It was one of these ghost gun prohibitions that are becoming pretty common throughout the country. But theirs was fairly extreme just in the way it was written. It was broadly construed to essentially outlaw all manufacturing of firearms within the district.
Yeah, even licensed manufacturing, right?
Yeah, even licensed. There was no exception in the language of the law, which is obviously very broad. And their definition of ghost guns, basically, like Heller pointed this out in the suit, could encompass things like Glocks or any other polymer frame pistol. Their definition relied on whether or not something could be detected by a metal detector, with all of the trigger group removed and the slide removed and the barrel removed. And obviously, striker fired polymer frame pistols. That's things like Glocks that are, legal even in states with ghost gun bans,
which could DC be covered by that definition. DC issues those guns to their own police department.
Right. Yeah. Yeah. It's the most common sidearm in the country, probably. So they filed suit basically saying, this is too broad. This goes way further than you can't even manufacture your own guns for personal use. And so the DC City Council, at the behest of the Attorney General, entered in an amendment and actually voted and approved it, basically to give a procedure for people to continue to self-manufacture firearms, so long as they get it registered and it's not a prohibited firearm that they're creating. They essentially backed down on the suit.
Right. Effectively, they gave Heller what he wanted, and they did that without being ordered to by a judge, which is very unusual in D.C. Usually they'll fight these things all the way to the Supreme Court in the past. And this time they didn't. So I think I might write an analysis piece for the members newsletter on Sunday, just detailing this and what it means and why it might have happened, what DC may be thinking here, why they back down so fast in this particular case. But it's another win for Heller. And then, of course, we have on top of that, the NRA. There's been several developments when it comes to the NRA, and none of them have been good. First, we did an excerpt from Tim Mack's book. He just published. We had him on the podcast not that long ago, a week or two ago, and we published a portion from this book, from chapter 11 in there, specifically about InfoCision, which is a contractor the NRA uses to fundraise, to bring in new membership. And we published the section that this discusses how the NRA will let InfoCision keep 100% of the over-the-phone credit transactions that it does whenever it brings in a new member or reactivates an old member, which essentially means that the NRA gets $0 from that transaction. So somebody who thinks they're paying dues to the NRA is actually just directly paying InfoCision 100% of their transactions. So it's something that I think maybe not a lot of people know or realize about the fundraising tactics of the NRA. And in effect, they're paying this InfoCision company more money. At least they did between 2008 and 2018. They paid them more money to fundraise for them than they actually brought in revenue.
Right.
So, it's just another one of these sort of sweetheart deals that the group has had over the years that are now facing increasing scrutiny, both internally and from the New York Attorney General, who wants to shut down the group, of course. We've covered quite a lot of that as well. She certainly has her own motives in the case, but these are the sorts of things that she's going after. Anyway, on top of that, unfortunately, the NRA has also been victim of a Russian ransomware hack that's ongoing and getting worse. In fact, we published a piece this week about how the thieves have released a new batch of documents, internal NRA documents, that unfortunately expose the personal information of many current and former NRA staff members. Dozens of them, in fact, have had their social security numbers and bank account information now leaked in this attack on the NRA. Apparently, it seems to be a ransomware situation where this group of criminals is trying to extort the NRA by hacking into their computers and releasing sensitive information. Unfortunately, the people that we spoke with who have been exposed in this attack have confirmed that much of the information in there is authentic, and also that they have not been contacted by the NRA about the leaks at all to this point, which the NRA didn't respond to our questions about the leaks, so questions about what they're doing to help those who've been exposed, or whether the leak is actually contained at this point. Because interestingly, the hacker group had posted, they'd moved the NRA section on their dark web website. They moved it from ongoing hack to completed hack, and it appeared that things were going to be over after the last round of leaks, which also included personal information from NRA staff members. And this is stuff from the lowest level teenage hourly seasonal workers to the highest levels of NRA leadership. Obviously we've kept, we are not republishing the documents, especially ones that include personal information like that. And we're not linking to where they're posted online, but these documents are freely available to anyone who can figure out how to get to the hackers' websites, which is frankly not that hard to do. They're also being collected into traditional file sharing services and shared around the internet. So it's thousands of people have seen this stuff already. And frankly, we just felt a responsibility to report that this is happening so that especially these NRA employees or current and former employees can try and protect themselves, or hopefully the NRA will step in and do something. It seems like that would be their responsibility in this case. But they haven't made any announcements or said anything publicly as to whether or not or how they're going to do that. So we're still waiting on that. And then in addition to the personal information that's been released, there's also a lot of internal budget information, internal financial documents in the NRA that things like their D&O policy for board members, which has been a point of contention. A number of board members resigned over the lack of one last year. Things like their cybersecurity guidelines were leaked as part of this. At least old ones, 2016 ones were leaked. The spokesman contracts, salary for employees. It's just a ton of stuff. There's hundreds of documents. You also have their membership models that give details on how many people are actually members, the specific numbers. Their budgets, their financial reports, a lot of this stuff is in there, and it's only getting worse, it appears, this hack of the NRA.
Right.
So
yeah, like you said, it would be nice to at least either get a comment or a public statement, just to let people know what they're doing to get a handle on this situation, doing something to prevent this from happening in the future.
Yeah, they haven't spoken since the first news of the hack back in October. And frankly, the media seems to have lost interest in this story for some reason. Yeah. Everyone covered this when it first broke back in October, but the documents released then were not terribly interesting. Frankly, it seemed maybe as a proof of, they were maybe just trying to show that they really did have access to internal documents when they leaked those ones. But the ones since then have been much worse for the NRA, and especially for its staff. So I don't know why there hasn't been much media follow-up to this beyond us. I mean, certainly I think the Reload is one of the only outlets that has the sourcing available inside of the NRA to confirm a lot of these documents, to authenticate them. And so perhaps that's why there haven't been a lot of follow-ups from other groups. But it's still concerning to me. I mean, I hope that those affected are aware. I mean, we've tried to, through our efforts to authenticate the documents, we've been in contact with a number of people who have been exposed, and they did not know. So I don't know. I think it's a terrible situation, but hopefully there won't be more people exposed in this. It's going to be difficult, I think, for a lot of those people to deal with their personal information being hacked. It's extremely unfortunate situation, but
absolutely.
Yeah, I don't know. Anyway, we also had, there's no resolution to that story, unfortunately, at this point. Hopefully there will be in the near future, and people will be protected in some way. I think the NRA owes them that much for sure. But the other piece of news that's dominated this week is the Rittenhouse trial, right? The trial of Kyle Rittenhouse, who shot and killed 2 people and injured a third during the Kenosha riots, is on trial for those shootings and has claimed self-defense, of course. And there's been quite a lot of attention, a lot of hyperbole, a lot of hot takes around that case from both sides. You've seen it, right? I've seen it. We've all seen it. And we, obviously here at the Reload, we try to be sober and take a serious approach to whatever story we're covering. And so today we're going to have an actual lawyer on the show to discuss the actual law and how these things are actually playing out in his expert opinion as somebody who's practiced and understands self-defense law in Wisconsin, where this is taking place. So I think we're going to head over to that interview now, and hopefully we'll be able to make some sense out of this whole situation and try to get a feel for where it's headed. All right, I'm here with John Monroe. We just had the Kyle Rittenhouse verdict come in, so I wanted to bring someone on who's knowledgeable in the area of legal self-defense claims. And John is a lawyer who's dealt with these exact kinds of cases in the past. So, John, if you could explain for the audience just a little bit about yourself for anyone who might not know who you are.
Sure. I've been practicing law for about 28 years. Licensed to practice in Wisconsin and in Georgia. I currently live in Georgia, but I still have quite a few cases in Wisconsin. In fact, I have a case at the Wisconsin Supreme Court next month. I'm going to be going up and arguing. I concentrate my practice on gun law litigation, both on the criminal and civil side. So this is the kind of thing that I work on.
Right. And that's exactly why we wanted to have you on. Obviously, we try to do things a little bit differently here at the Reload. We look for, more sober, serious analysis of events. We're not about hot takes. So I wanted to have somebody on who's had direct experience in exactly this kind of case. Rittenhouse has been charged. It was charged in Wisconsin, and he pled that he had a self-defense claim in the case. He now has been ultimately successful. All of the charges against him, he's been found not guilty. One of them was dismissed before going to the jury as well. That was a misdemeanor weapons charge. We can get into the details of all this, but I just wanted to make sure we had someone on who actually knows what they're talking about. I know that's maybe a novel thing in a lot of media outlets. So that's where we try to set ourselves apart a bit. So are you surprised at all by the ruling we just got?
I can't say I'm surprised. It seemed at the outset like it was a decent self-defense case, but you see some video clips on the news and things like that. You don't necessarily get the meat of things. So there could have been more information that that wasn't readily apparent. In fact, I think some video did come out at the trial that hadn't been shown before. But from the outset, it looked like there was a decent self-defense claim.
Yeah, that was my take on it as well from the beginning. There's a lot to be said about the circumstances that led up to these shootings and Rittenhouse being in Kenosha that night. And actually, we'll probably get into that a little bit more. I'm going to talk with David French about this next week. But I think when you look at the actual shootings themselves and the things he's actually directly charged with, it seemed fairly clear from the beginning, given all the video in the case that was publicly available right from the start, that he had a pretty good chance of making a strong self-defense claim. And clearly the jury agreed with that. Now, what in your mind, what are the key elements here to him successfully putting on a self-defense claim in this case? What do you think it was that really, what are the, in Wisconsin specifically, right? Because there's slight variations from state to state. What are the key pieces of information or the key elements to a self-defense claim?
Yeah, in that regard, Wisconsin's not so different from most other states, really. In order to have a self-defense claim, you have to reasonably believe that force is necessary to prevent imminent death or great bodily harm. And the amount of force that you have to use to prevent that death or great bodily harm has to be reasonable. So there are two reasonableness requirements in there. You have to have a reasonable belief, and you have to use a reasonable amount of force. Right.
And that's ultimately what this case comes down to, is whether fear for your life whether Rittenhouse was really reasonably fearing for his life or serious bodily harm, and whether or not the force he used to prevent that or respond to those threats was reasonable. And I guess in both cases, the jury here said yes. Now, another thing is they charged him with a couple of lesser crimes in addition to the murder charges. And one thing I'm actually curious about is if they find he acted in self-defense for the larger charges, the more serious charges, does that just follow down naturally to the lesser charges, or how does that work in Wisconsin?
No, not really. Each of those, you're talking about the 5 felony counts, I think, right? Not the 2 misdemeanor counts that the court dismissed early on.
Yes.
For each of those would be analyzed on its own because each one of those had a different victim. So you'd have to look at each of those alleged crimes and it stands or falls on its own as far as self-defense is concerned. Like, for example, the first shooting that night of Mr. Rosenbaum, you'd look at that to see whether there was a reasonable belief there, and then whether the amount of force used was reasonable, and then you'd move on down to the other charges. The Rosenbaum shooting is probably the most important one in the case because the theory of the prosecution was, well, these bystanders either saw Mr. Rittenhouse shoot Mr. Rosenbaum or they heard about it, so they were chasing him under the theory that they were going to stop him because he was an active shooter. So if the Rosenbaum shooting was not justified, then it would be reasonable for the bystanders to try to subdue the active shooter. If it was justified, then based on the video and the testimony at the trial, then the bystanders were attacking him. And it'd be hard to come to the conclusion at that point that the shootings weren't justified. You had one guy hit him with a skateboard. You had another guy point a gun at him. It'd be hard to come to a conclusion that using deadly force would not be reasonable in those circumstances if the first shooting was justified.
That's interesting. So because that first shooting, the jury determined that he was justified in using self-defense in that situation, using deadly force, the later shootings are impacted by that as well. Even though, I mean, I'm sure maybe perhaps some of these people who did attack him later on genuinely believed that he was fleeing this, that he had done something terrible. That's interesting that it's still a lot of that hinges on whether that first act, that first shooting was justified or not.
Right.
And so I think one of the key things here in the Rosenbaum incident, the first shooting, is there's some suggestion, right, by the prosecution that the force used was not only was he not reasonably in fear for his life, but the force used was too much because Rosenbaum was not armed, right? And so, can you speak to that a little bit? How that works in the law as far as an armed assailant versus an unarmed assailant?
Sure. I mean, things might have been different if Mr. Rosenbaum had been armed, but the prosecution, I think, probably put too much stock in whether or the fact that he was not armed, because you really have to look at the facts of that specifically applied in this instance. And he wasn't armed, but even one of the other alleged victims, Mr. McGinnis, testified that Mr. Rosenbaum lunged for and tried to grab the barrel of Mr. Rittenhouse's rifle. And it's, I think it's widely understood in circles where people who are routinely armed, such as police, that if someone tries to take your gun, if they're successful, you're going to get shot with it, or at least someone's going to attempt to shoot you with it. So I think it's widely understood that if someone, a non-friendly person, tries to take your gun, that if you don't use deadly force, they will. So the fact that he wasn't armed doesn't really matter when you consider what he was doing is trying to disarm Mr. Rittenhouse.
See, that's interesting too. I'm definitely following you there, but that also obviously brings up another case in Georgia where you are, the other jurisdiction where you try these sorts of cases. Obviously, Ahmaud Arbery, that case deals with the Rosenbaum shooting and then the shooting of Ahmaud Arbery in the actual struggle before shots are fired. There's some similarities there in the idea that Arbery was grabbing at the gun in that case as well. But I think a lot of people would imagine that those two cases are probably going to come out very differently in court. We don't have a verdict in the Arbery case yet, but I think most people expect that that's a much harder self-defense claim to make. Can you talk a little bit about why, one, if that's your view, and two, why there would be a significant difference, because both of those shootings involve somebody grabbing the gun of someone else before being shot?
Yeah, I first of all, that is my view. I think there's likely to be a different result there. It's not a foregone conclusion by any means, but I mean, the cases are really very factually different. In the Rittenhouse case, Mr. Rosenbaum was chasing Mr. Rittenhouse on foot, and Mr. Rittenhouse ended up being cornered more or less by physical objects, not by other people, so that he essentially ran into a corner, had to turn around, and that's when Mr. Rosenbaum lunged at him and tried to take his gun. In the Arbery case, Mr. Arbery was the one being chased. He was on foot. He's being chased by, and he was unarmed. He was being chased by people who were armed. And he essentially got cornered by multiple people chasing him, and then reached for, it's not on the video very well, but it appears that he reaches for or lunges for the shotgun of the first guy who was at him. So there's more of a case there that Mr. Arbery was making a desperate attempt to defend himself because he was being attacked. And in the Rittenhouse case, there's not really much of an argument that Mr. Rosenbaum was being attacked by Mr. Rittenhouse, because Mr. Rittenhouse was running away from him.
Right. Yeah, I think that sums up pretty well the big difference between those two things, because obviously they both involve a struggle over a firearm. But in one case, you have the person shooting who was being pursued and assailed by the person who got shot. And in the other case, you had the person who got shot was being pursued and assailed by the person with the gun. And I think that's basically the key difference as to whether or not the shootings themselves are acts of self-defense.
Right. If you would have just transposed Mr. Rittenhouse and Mr. Rosenbaum and say, for instance, that Mr. Rittenhouse had been chasing Mr. Rosenbaum got cornered, and then he turned around and tried to grab the gun and got shot, that would have been a very different case.
Now, there is a discussion, of course, too, about along the same lines with the Arbery case about whether or not Rittenhouse was instigating these events just by being there in the first place. Can you talk a little bit about that? I mean, obviously, there's a lot of people who don't agree with him going to Kenosha in the first place. Is there any sort of legal consideration with the fact that he was there ostensibly trying to protect businesses from rioting, in his sort of personal capacity? Does that play any role in the legal claims at hand?
Not really. And the reason for that is as long as he was there lawfully in the first place, his own motivations for being there and that kind of thing don't really matter. There was nothing illegal about him being there. There was nothing illegal. The court has ruled now about him having the rifle while he was there. So he was acting lawfully. Whether or not he should have, as a matter of public policy or morally or anything like that, that doesn't matter. He was there lawfully, and while he was there lawfully, he was attacked. You could say the same thing about somebody going to a party and drinking a lot or something like that, and being out of control in that regard. It's legal to do that, and so if you're under those circumstances and you get attacked, you can still defend yourself. So the fact that he was somewhere doing something that some people might think he shouldn't have been doing, it wasn't illegal. So he was entitled to be there if that's what he wanted to do.
Yeah. And to that point about him having the gun, right? He's 17 years old. Technically, he lives one state over. This was sort of made there's a lot of hay made about the fact that he crossed state lines, right? Even though I believe he lives very close to Kenosha, even though it's technically across state lines. But a lot of people thought this was a very important point. And, he's carrying a gun that he can't legally purchase himself. And he was obviously charged initially with a misdemeanor for possessing that gun. What are some of the legal implications there? I guess there's a number of things we could talk about. I think first, the dismissal of the charge. Can you explain that statute a little bit? Because it's certainly confusingly worded, which I think, if I understand correctly, played into why it was dismissed, why this charge was dismissed. But there's a prohibition against minors carrying guns in Wisconsin, but there's an exception about there's sort of an exception written into that statute about how it only applies to short-barreled rifles or potentially to somebody who doesn't have a hunting license, but it's sort of confusing. You understand the law there better than I do. So can you just talk a little bit about why that charge was dropped in your view and what that law is supposed to mean?
So, that particular statute is not so unusual compared to other statutes when they get written and then changed over time. So you start off with a law that says it's a crime for someone under 18 to possess a firearm, period. And then later you say, oh, well, but it's okay. We actually allow minors to go hunting with long guns. So it could have been worded better, probably. But basically, then the wording that was put into the exception is that the prohibition against possessing a firearm doesn't apply to, and they didn't call it long guns, but the description they used basically means long guns. So it would have been simpler just to say it's against the law for a person under 18 to possess a handgun and then leave it at that. But that's not the way the statute was worded. It says it's against the law for someone under 18 to possess a firearm. And then you read on down farther and it says, but this doesn't apply to a minor possessing a long gun. It's really awkward to say it that way, but the bottom line is he never should have been charged with that. If you read the complete statute, it's pretty obvious. It doesn't apply to minors possessing long guns, period. So it shouldn't have been charged. I think multiple times motions were filed to dismiss it, and it was not dismissed until pretty late into the game. But that never really should have been a charge.
Okay, so you don't take the view that it requires the minor to have a valid hunting license in Wisconsin for that to apply?
No, it doesn't say that. And there are a couple of different doctrines that apply. Probably the most important is criminal statutes are construed strictly against the state and in favor of personal liberty. So if it's kind of awkwardly worded or there's some debate about, well, this only applies if you're hunting, if that's not what the statute says, the state loses. That's just the way criminal statutes are interpreted. So I think maybe the purpose of the exception is so that minors can go hunting with shotguns and rifles, but that's not the way it's worded. It just says it doesn't apply to carrying or to possessing long guns. So you don't have to go any farther than that. That's what it says. The state loses.
Yeah, I mean, that certainly seems to be how it came out in this case. It didn't even make it to the jury, right? It got dismissed. Right. But I think the prosecutor in this case the two prosecutors made a number of very perhaps controversial claims during the case. For instance, there was a lot of talk about the fact that Rittenhouse brought a gun to this event. And at some points, at one point, it was actually said directly that you forfeit the right to self-defense if you're bringing a gun to a place where you know there's going to be violence. Can you talk about that a little bit, perhaps?
I think that's an absurd argument. I mean, if you're just going into the woods for a walk by yourself, you might say, well, the chances of me encountering somebody are pretty slim, so I'm not bringing a gun. But if you go to an urban center where there's known to be a lot of crime, you say, well, that's a dangerous part of town, so I'm going to bring a gun. To say that you can't use self-defense because you purposefully bought a gun to a place where there might be violence, where are you going to bring a gun except to a place where there might be violence? I mean, that's kind of borderline frivolous.
And then there was at a later point, the other prosecutor made an argument that Rittenhouse effectively, he brought a gun to a fist fight, I think was the quote, and that he should have, instead of shooting Rosenbaum or the others, he should have physically fought them with his fists.
Yeah, the way self-defense works is you have to have the reasonable belief, and apparently that argument at least accepts the reasonable belief, and it sounds like it's more of a test of the second part of it is you have to use the force that you use has to be reasonable. The fact that you might have been able to use less force, that's not the test. The test is whether the amount of force that you used was reasonable. So maybe if he'd had a taser with him, maybe that would have been just as effective and would have, been enough. But that's not the test. Either the shooting was justified or it wasn't, regardless of whether some smaller amount of force would have been okay.
Right. It's not, the standard isn't just the jury. I mean, although I'll be fair, a lot of this is kind of the jury second guessing what you do.
Exactly. Yes.
In a situation like this. So I think that is something that should become clear to people who carry guns, like myself and others. This is what a self-defense trial looks like. You're going to be second guessed on everything you did.
Yeah. I teach a lot of classes on the law of self-defense, and people will ask me, well, what if this happens? Can I shoot the guy? And I'll say, maybe. I mean, I'm not the one who's going to decide, though. 12 other people are.
And that also gets back to this difference between the Rittenhouse case and the Ahmaud Arbery case, in that I think most people, even though you could point out some similarities, like the struggle over the gun with Rosenbaum and Rittenhouse and Arbery and his assailant, most people, I think, reasonably can see a difference between those two situations because of what you articulated earlier. And oftentimes that's what these things come down to. And I guess we should maybe cover the other three shootings here. There were three shootings, I guess, in the later part of the night after he was apparently running to try and get to the police after he shot Rosenbaum. Rittenhouse was running down the street. That's what he claims. He was trying to get to the police. And that's where he was, I guess, for a better word, attacked by the crowd, who perhaps thought that he was, had committed. Maybe they thought they were trying to detain him. I don't know. It's hard to, obviously, in a chaotic situation like that, to judge everyone's motivations. But regardless, he was obviously attacked. He falls down at this point, and then people start. One guy tries to kick him in the head, and I think Rittenhouse takes a shot at him. I guess then there's the guy with the skateboard who does successfully hit him with the skateboard after previously trying and failing while he was running. And then he's shot and killed. I think he also grabs Rittenhouse's gun at that point. And then you had the third person who pointed a gun at him before he was shot in the arm, not killed, but he testified at the case too. Actually, that was kind of a big moment in the case, was his testimony, the other guy who was armed, where he effectively admitted that, yes, Rittenhouse didn't actually shoot him until he pointed the gun at him. And this was a fairly big revelation. It was treated as such, especially on the side of people who were supportive of Rittenhouse's case. But to me, I thought that was another example of like something where it was on video the whole time. It's just kind of confirming what was already on video. And I feel like that's true of a lot of this stuff that came out during the trial.
Well, the last shooting of Mr. Grosskreutz, the one who had the handgun, it looked in the video. I mean, you could see in the video that he had the handgun, but at least from the videos I saw, it was not obvious what he was doing with the handgun. But he testified at the trial that Mr. Rittenhouse didn't shoot him until he pointed his gun at Mr. Rittenhouse, whether he did so intentionally or not. He said he pointed the gun at Mr. Rittenhouse, and that's when Mr. Rittenhouse shot him. So I think that testimony made a difference, because the video, to me, it seemed fairly clear that the shooting of Mr. Huber with the skateboard was probably justified. I mean, he's on the ground on his back and he's being hit by somebody with a skateboard. I mean, that's a pretty violent attack. It was less clear what was going on with Mr. Grosskreutz, the guy with the handgun. But then he himself testified at the trial that he pointed his gun at Mr. Rittenhouse, which I think, that justified the shooting then at that point.
Yeah, I think he had admitted to this when he was shown an image of himself pointing the gun at Rittenhouse before the shot was fired. I think it was a still image that they used in court, but I had thought that came from one of the videos, but I could be wrong on that front. It seemed to me, watching his testimony, it was fairly clear that he was just sort of admitting to what was on the image he was being shown. But yeah, I think those points are very relevant as far as those two shootings and why they would be justified. I think also what helped his case a lot is what happened immediately before those two shootings, before he pulled the trigger in those situations where he fell down. Somebody tried to kick him in the head, and then he pointed his gun at two other people who stopped and put their hands up and backed away, and he did not shoot those people. And I think that's another thing that kind of perhaps helped him in this case. Would you agree with that?
Somewhat, yeah. I think the bottom line is in all three. I'm discounting the shooting where it was an unknown victim and he didn't get shot. So the three people that did get shot, in each of those instances, Mr. Rittenhouse was either running away, had been cornered, was on his back, which I guess is the same as being cornered. So in all those, he was being attacked, and that's it's different from, like, for example, what was going on in the Arbery case. So I think the fact patterns leading right up to the shootings are really important for each of the shootings.
Yeah, certainly. What do you think this says, if anything, about self-defense law moving forward? Do you see any? This is a high-profile case, but does it have any real impact beyond just this actual trial?
I haven't heard if there's been much of a reaction right there in the community in Kenosha. I suppose there probably will be some, but as far as going forward, if it's going to change self-defense law, I don't really picture that. I think this was, even though it was sensational, got a lot of nationwide coverage and everything, I don't think it was an unusual case in terms of analyzing self-defense. I think it was fairly straightforward.
Yeah. Honestly, I have to agree with you there. I haven't written a whole lot about the case because of that, really, because it doesn't seem like something that was especially remarkable in terms of the self-defense claims being made, given what's on, and a lot of it's on video. So it's like, there's not a lot of back and forth as to what happened.
Right.
You have more of that in the Arbery case because we only have the actual shooting on video, whereas everything before that is, there's more perhaps nuance or unknown facts that go into that even. But yeah, this does feel like a cut and dry self-defense case. I mean, obviously what led up to it is not normal, right? I don't know how many cases have you dealt with that stem from rioting?
Yeah, that part is rare. I mean, usually self-defense cases, there was the shooter and there was the person who was shot or who was killed. Maybe there was another eyewitness, and maybe there was some video or something, but they're generally pretty low key events that erupt suddenly and are over just as quickly. Whereas this is something that had been going on for hours and hours and hours, even overnight. So it's that part's unusual.
And I guess we talked a little bit before about how whether or not it was a good idea for him to be in there in the first place doesn't really play into the actual self-defense claims in the case. Could you say the same thing about the rioting that had been going on, across the country really beforehand? Does that play any role into Rittenhouse's potential fear for his life in this situation? Is that something you think that the jury considered when they were deliberating whether or not he had fear for his life, given, at the time there had been a number of extremely violent riots around the country? Does that play any role, or is that another thing that's just kind of ancillary?
Well, it might be a little bit of each. I think it's mostly ancillary, but it might help explain why he was doing what he was doing leading up to it. I mean, he was walking down the street in the middle of the night with a rifle on his back, on a sling, and he was carrying a medical pack and offering medical treatment to random people on the street. Those aren't typical behaviors. None of them are illegal, obviously. They're just not. They're not that typical. So the fact that there was rioting going on, and people were setting dumpsters on fire and cars on fire and porta potties, and they were being tipped over, and I think cars and car lots were being vandalized. So I think that backdrop has some role in explaining why he was doing what he was doing and where he was doing it. But by the same token, it's kind of ancillary, because even if it had been in the middle of the day, in the middle of the week, with no other events going on, and Mr. Rittenhouse had chosen to walk down the main street in Kenosha with a rifle slung on his back at 2 a.m, carrying a medical pack, again, those aren't illegal behaviors. They're just not typical. So if that's what he had chosen to do, and the same events would have happened, I'm not sure there would have been a different result.
What about, and this kind of veers off from the facts of the case a little bit. So I understand if you don't want to speculate here, but in this case, you had someone who went to Kenosha to defend the property of friends or acquaintances or friends of friends, I guess it was. And I guess that doesn't, like we discussed earlier, perhaps that doesn't matter so much because of the actual details of how these self-defense shootings occurred, because he was physically attacked and people were physically attacking him personally instead of property. He wasn't shooting people over defensive property in this case. No one argues that. That might be why he was there generally, but in the specific incidents, that's not why he started shooting at people. But what if that had been the incident? Like, what is the self-defense law around, especially in Wisconsin? Because I think a lot of people perhaps have a too wide view of what the actual law is on defending your property. Because what if he had been defending the car lot and shooting at people for trying to set fire to the cars? Would that be would he have any self-defense claim in that, or not self-defense, but would he have any viable defense if that had happened?
Right. So in order to use deadly force, in order to shoot at people, the first prong is you have to reasonably believe that there's imminent death or great bodily harm to yourself or somebody else. If you're up, I think they were up at the first car lot, they were up on the roof, basically, just kind of looking out. If you're up on the roof of the car lot and people are coming up and, smashing the windows of the cars or setting them on fire or something like that, you're up on the roof out of harm's way. You can't really reasonably believe that there's imminent death or great bodily harm. There might be imminent great property destruction, but that's not good enough reason to employ deadly force. It's good enough reason to employ force other than deadly force You certainly can, can physically push people out of the car lot or that kind of thing, but you can't use deadly force to prevent something like that.
Yeah, I guess in a riot, that's where it becomes kind of, the line becomes blurred on that kind of stuff though, right? Because if you're in a building and someone is coming in to set fire to that building, like where's the line on what's self-defense and what's property defense at that
Well, that's
point?
another matter. If you're in a building and somebody's setting the building on fire, I mean, that might be a reason to justify deadly force. I mean, if you're going to be cornered or trapped in the building and somebody's firebombing the building, then you have reason to believe there's imminent death or great bodily harm. But if you're up on the roof of the car lot office building and people are just vandalizing the cars out in the parking lot, I don't think you have reason to believe there's imminent death or great bodily harm.
And then I guess on top of that, you also have the consideration of like, it's one thing if it's perhaps your property, right? But what if you're defending someone else's property? Then, I feel like as you get further away from someone physically directly attacking you, it gets harder and harder for you to justify using deadly force, right? I mean, that's kind of the general principle here.
I mean, that's somewhat true, but if you're only talking about deadly force, if you reasonably believe there's death or great bodily harm to you or somebody else, then you can use deadly force. But if you're only defending property without any reasonable belief of imminent death or great bodily harm to you or somebody else, it doesn't matter whether it's your property or somebody else's property, you're not privileged to use deadly force.
Yeah, no, very good point. I just obviously in a riot situation or a mob situation, the lines start to get blurred as far as when it becomes a threat to your physical safety, when property destruction turns into threat to your physical safety. But certainly, I would imagine that you would caution most people to be very sure that they're under their own physical safety is being threatened before they employ deadly force in any situation, right?
Sure. I mean, if somebody's stealing your TV, it's just not worth it. You can buy another TV.
Yeah, because there are a few states out there that are exception to this. We saw this with the McCloskeys, where some states have broader protections for defending property. Texas, I believe, is another one. But even in those states, you probably want to be extremely cautious about using deadly force in any situation. I mean, it's sort of common sense, obvious thing.
Right. Yeah, there's some states that extend the privilege to use deadly force to, for example, burglars, regardless of what the burglar's doing. And the theory is you don't have to wait to find out what they're doing when it might be too late. But that's kind of a special case when you find somebody who's broken into your house in the middle of the night, as opposed to somebody who's just walking down the street having just taken your TV or something like that. Yeah.
Certainly, the castle doctrine is something that a lot of states employ, but because the theory is you don't know why that person is broken into your house. But I think even in Missouri with the McCloskeys, their protection, their laws are pretty expansive compared to what I thought they were, and compared to I think the rest of the country. But even then, you should avoid using or threatening deadly force at all as much as you possibly can, because as we saw in this case, I mean, it took them 3-4 days to come back with a not guilty verdict. So it's not like it was a slam dunk thing here. If you kill someone, you're going to face very heavy scrutiny regardless of the circumstances.
Well, and it's conventional wisdom is that if juries come back quickly, that it's a conviction. It takes them longer to sift through the details to see if somebody was privileged than it does to just decide somebody was guilty.
Interesting. All right. Well, we really appreciate you coming on and giving us your expert view on this case and the details of it and the ins and outs and why perhaps the jury went the way it did. So thank you so much for joining us. And perhaps we could have you on again in the future. Maybe we'll when the Ahmaud Arbery case, when that jury comes in, perhaps we could have you back.
All right.
On.
Sounds great. Thanks for having me.
And that is it for this week's episode of the Weekly Reload podcast. I'm your host, Stephen Gutowski, and I will see you guys next time. Make sure you stop over at thereload.com and buy a membership today to keep this thing going. Plus, you'll get access to all kinds of exclusive reports and analysis pieces. So it's a great value, I think. And I think you'll think that too. So head over there, check it out, buy a membership. And if you're skeptical, join our free newsletter. See what we're all about. Anyway, I'll talk to you guys again next week.